Welcome and welcome back to Really Legal. I am attorney Ethan Bearman. So Elon Musk and his rebranded Twitter called X got its butt handed to it in court late on Thursday. It's wild. It's one of the most interesting rulings I have ever read. I will give you the good, the bad, and what's next. So if you love the Cybertruck, unlike apparently so many of the owners, you are not going to love what happened to Elon in court on Thursday. His company, Twitter, through its attorneys, attempted to stop a data scraping, data broker company called Bright Data from gathering information from X, a public website, and selling it to companies. That's what Bright Data does. There's tons of these types of companies around. If you don't know that now, you should know that. Any service that is not charging you money and putting you behind a paywall, there is data scraping. It's being sold in various ways, and that's what's happening. So, pull your finger out of the Cybertruck trunk or frunk and get ready for what you're about to hear.
Happens. Ready? Ow. Okay. Oh my God. Ow. So I can confirm that is not a good idea.
About a year ago, the lawyers for X Corp filed a lawsuit against Bright Data. And what's fascinating here is this was a completely novel argument. And the judge that they were put in front of is famous. I'm going to start by saying I have never met him. I have never argued a case in front of him. I hope I get the chance to one of these days because he is a model for judges in Silicon Valley. He's brilliant. His undergraduate degree was in mathematics. He learned how to code in the 1980s, and he has handled some of the biggest cases. Oracle v. Google regarding the use of Java. That was this now senior judge, William Alsup, in the Northern District of California, and he utterly destroyed X Corp in his ruling in a motion to dismiss that was granted, and he essentially excoriated. I'm going to start with the finish line here, and then I'm going to get into some of these details because it's utterly fascinating, and this case actually bears very heavily on what's happening with the internet today and what companies like X are trying to do. I mean, Mr. Greedy moron sometimes himself, who, by the way, I'm so glad really did revolutionize electric cars. I've always said that. And for that matter, space travel and transport, he has revolutionized as well. Many other things he's done, not so cool, not so positive, really jerky in a lot of ways. By the way, dating back over 10 years, my very first paid published article was ripping on Elon Musk long before it was popular. As a matter of fact, I got the crap beat out of me for ripping on Elon Musk back then. Take a look at this. Yeah, there's the picture. So he's never been a great guy. He has great ideas. He's smart and he's a moron at the same time. Whatever his ego is, whatever it's rooted in, causes him to do really stupid and bad things like buying Twitter. Absolutely moronic on his part. It was a horrifically bad move, at least from a financial perspective. $44 billion to buy a company that had profits in the low hundreds, if not tens of millions of dollars. Why would you pay $44 billion for it? It was a lark on his part and has not turned out well, and it's deeply damaged what was, and I think to some degree still is, an important social media platform. So he wanted to monetize the crap out of it. And one of the ways is through this lawsuit against Bright Data. So in conclusion, from Judge William Alsup, he said, for the foregoing reasons, the motion to dismiss for failure to state a claim is granted, and the instant complaint is dismissed, meaning the defense, Bright Data, said, you got to dismiss this case, Your Honor. It fails to state a cognizable claim under the law with sufficient facts on its face to survive what's called the Twombly and Iqbal standard, or as my professor long ago taught me, the Twickball standard. So that's what happened here. He said, no, you don't even make it past this. So too often, people in the media and on social media love to say, oh, it made it through the motion to dismiss. That's a huge celebration. No, it's a huge celebration when you're granted a motion to dismiss. Far more often than not, cases make it through the motion to dismiss. It's not often that motion to dismiss is granted, especially in a big case like this with big name, high power, high paid attorneys. They usually would make it through the motion to dismiss. That's how bad this case was. So continuing from Judge Alsup, subsequently filed motions and requests that remain pending will be considered if and when X Corp provides a viable complaint. Boom. X Corp may seek to leave to amend its complaint by motion no later than Thursday, June 6th at noon. Also an odd time of day. Usually you have until the end of the court day to file something, but he's saying noon on Thursday, June the 6th. Any motion for leave to amend should affirmatively demonstrate how the proposed amended complaint corrects deficiencies identified in this order as well as other deficiencies raised in Bright Data's motion. It should be accompanied by a redlined copy of the proposed amended complaint showing all proposed amendments. If X Corp seeks leave to amend, it must plead its best case. Otherwise, judgment will be entered. That is just a very, very brutal conclusion by Judge Alsup. That is very harshly worded because they failed so badly. This is a lengthy ruling on the part of Judge Alsup because he just destroys X Corp in this granting of the motion. He destroys Twitter. He destroys Elon Musk. He rips them apart piece by piece. So let's get to the crux here. So I already described Twitter wants to own its data. It doesn't want to be liable under Section 230 of the Communications Decency Act. As some of you have heard, this is why Facebook and Twitter and others are not civilly held liable for something somebody publishes on their platform. Way back in the 90s, our government, our Congress decided that we wanted a free and open internet to compete. We wanted a free marketplace. I mean, here, take a look. Here's Title 47 Code Section 230. The government wanted to, it's the policy of the United States, to promote the continued development of the internet, to preserve the vibrant and competitive free marketplace, to encourage the development of technologies which maximize user control over what information is received by individuals, families, and schools, to remove disincentives for the development and utilization of blocking and filtering technologies, and 5, to encourage vigorous enforcement of federal criminal laws to deter and punish trafficking in obscenity, stalking, and harassment by means of computer. So they're protected. Twitter, Facebook, TikTok, etc. They're protected by this Section 230. It's a powerful piece of code that both the right and the left have issues with and want to modify. But that is the law of the land as of today. It is. It's May 12th, 2024. I don't know why I think it's March anymore. But Twitter grants itself a non-exclusive license to the user content, which is in conflict. They can't take a full copyright ownership of the user content. They take a non-exclusive, so they're still protected by Section 230. And what Judge also rips them up about in this ruling is, look, you can't allege that somebody's stealing your data when it's not your data to begin with, and you don't show harm as a result. In the state of California, our Supreme Court has ruled in the state of California that any breach of contract claim, which is their first claim from Twitter in this case, must be accompanied by damages. So in this state, nominal damages generally don't make your breach of contract claim make it through. So sorry, let me take a step back. Even though this case is in federal court in the Northern District of California, a little brief law school 101 lesson for you. State court uses state law, state civil procedure, can use federal law if it's a federal question. Federal court uses, if it's a state claim, like in this case, it uses state law and federal civil procedure. So the state of California's civil procedure is its own whole gigantic book called the California Code of Civil Procedure. And in a federal court, it's called the Federal Rules of Civil Procedure. There's some similarities and there's some real differences. I won't get into any of those here, but you can research it on the internet. But so Twitter claimed breach of contract. They claimed tortious interference with contract. They claimed trespass to chattels, which I can talk about a lot, because that's something that I actually plead at various times for clients. It's a legit claim that was used illegitimately, in this case, according to Judge Alsup. Violation of California Business and Professions Code 17200, that's the unfair business practices that are used to abuse people or other companies, etc. And then there's this misappropriation claim as well. And Judge Alsup said all of these fail on their face. But it's really important under the copyright side, he really excoriated Twitter to say, you didn't give yourself an exclusive copyright, and you didn't because of Section 230. And as a result, you don't own the data that you're accusing them of scraping. And by the way, what you're accusing them of scraping is publicly available, regardless of things like CAPTCHA. So you absolutely do not have the right to solely own selling your own data on a publicly available website. That's the key again. If it's behind a paywall with security, there are different rights associated. In a publicly available forum like a social media platform, you don't get to claim that you're the only one who gets to scrape the data and sell it. That's the summary of this case. This was really, really powerful. I encourage you, if you're at all curious, to read the whole thing. It's quite the read. I'm telling you, this was one of the most amazing rulings I've read out of federal court in quite some time. Because again, this is really specific to tech and big tech. This isn't just a politics case and insurrection and, government records or the Presidential Records Act. This is something that actually affects all of us equally. And in this case, so let me get to the good, the bad, and what's next here, because I think this is a really important case. The good is this judge gave the finger essentially to X, to Twitter, to Elon Musk, and said, you're not the only one who gets to make money on publicly available information. You don't own it, and you chose not to own it so you could get Section 230 protection. That's a really important protection. Any lawyer who's dealing with a social media or public-facing website like that is going to strongly encourage anybody to avail themselves of Section 230 to prevent many, many, many other lawsuits that could be brought against Twitter. So it's a really great ruling here. It's very, very strong to say, look, you're putting it out on the internet. Somebody else comes along and scrapes. By the way, one of the other key things in this ruling too is just because somebody uses a proxy server, there is no requirement on the internet when somebody comes and visits your public website to share who they are and where they are accurately. That's also in this ruling because there's precedent for it in the Ninth Circuit here. I think this is just such a big deal case because it's telling the Facebooks, it's telling the TikToks, it's telling the Twitters, and anybody else who comes along, you got to abide by the rules or you're going to lose. I mean, it's just that simple. So what's the bad out of this? Well, I don't see it as really bad. He did give Twitter a chance to modify, amend their complaint a second time because they had filed a first amended complaint. And one of the things he also shot down in here is they changed their terms of service after filing the initial complaint. They changed their terms of service to more strongly, more forcefully protect their contract rights. And the judge just absolutely, again, shot that down. Judge Alsup, my goodness, amazing. He's so smart. He is if you read any of his rulings and read about him, He is so incredibly intelligent. I mean, if I were to ever become a judge, he's like my model. I'll just say that for me. I can't get over it. This guy. It just sees through the BS. He understands things very deeply, and he just shoots it down left and right. So the only bad is that they have the opportunity by June 6th at noon to file a second amended complaint. So what is next? Well, for now, the case is almost dead. It's on ice. It's not actually dead yet. June 6th noon, we're going to find out if it's dead or not. I'm very curious if Twitter's attorneys want to get themselves in hot water here by filing a frivolous or not following his order very, very closely. When a federal judge gives you a specific order like Judge Alsup did in the conclusion, you better adhere to it tightly or you're going to subject yourself possibly to sanctions. And Judge Alsup made it very clear what he wants from the Twitter attorneys. Elon Musk, it's amazing. I'd love to hear your comments below. Tell me, what do you think about this case? What do you think about Tesla and Elon? You know how much I love your comments. Keep them coming. I really, really love reading them. Click that like button. Share this video with your friends and on other social media platforms. It's very, very helpful for us here at Really American. Smash that subscribe button. Really appreciate you. Thank you so very much. I'm attorney Ethan Bearman. This is Really Legal on the Really American Network.